Welcome everyone to today's webinar, New York State Expression of Breast Milk in the Workplace, presented by Ariana Kwiatkowski with Barclay Damon. Many thanks to our presenter Ari for being with us today and to all the participants who've joined in. Please note this webinar is being recorded to share what we learn with the business community. All attendees will receive the link to the recording. Ari will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Ari to start things off.
Great. Thanks so much, Beth. Good morning, everyone. Thanks for joining. As Beth mentioned, if you have questions throughout the presentation, please feel free to just pop them in the chat and I'll answer all questions at the end just to keep things flowing. So bear with me here. Here's just my contact information. I'm on LinkedIn. You can find me on social media. Just a quick plug, Barclay Damon has a labor and employment podcast. We've talked a lot about this topic. Basically, the purpose of the podcast is to keep employers up to date on what you need to know. Obviously, the law in New York and now federally is always developing. So if you want to check that out, you can find it on our website. We're also streaming the podcast on all typical podcast streaming platforms. So I will just jump right into it. Today, we are talking about the amendments to labor law, section 206C. Basically, this is expanded protections for employees who are breastfeeding in the workplace. There have been applicable laws that have applied to this situation. The previous version of the labor law and the Federal Pump Act, which is a law which is part of the Fair Labor Standards Act, which many of us on the call may be familiar with. We'll talk a little bit about that later because there is some interplay between the amendments to the New York State law and the Pump Act. The New York State law is more protective than the Pump Act, the federal law. So if you have employees in New York, the New York State law will apply. This law went into effect 180 days after December 19th. I think if my math is correct or my Googling is correct, it went into effect on June 17th. So it is currently in effect. So if you have employees in the workplace who are breastfeeding, there are definitely some things that you want to know. So here's just a general overview of the expansion of Labor Law 206C. Basically, this says that there's no limit on the number of times an employee can use unpaid break time or paid break time to express milk in the workplace. We'll talk about that. There's a broadening in the law, a change from the term mothers to employees who are expressing or have the need to express breast milk in the workplace. There's some expanded room requirements. This is really the thick of what the amendments purport or propose. So we'll definitely get into detail on that. There is also now a written policy requirement under New York State law. So I know that, employers in New York, there are so many policies to keep track of, especially with the new amendments to the labor law at the end of last year, which said that your policies should also be made available electronically. But this is another one to put on the list. So we'll go through that. And with the materials that I sent over to Beth is included, there's some guidance from the New York State Department of Labor, which is the agency that's enforcing this law, of course. And there is actually a sample lactation accommodation policy. So you will talk about that. Our recommendation is New York State has provided the policy, just adopt it verbatim, save yourself a headache. Also, the DOL has been pretty good about this particular amendment. There is a website devoted to telling you what you need to know about it, what employees need to know, what employers need to know. So I just wanted to provide the link for you here. So let's get into what the statute basically says. Essentially, the amendment provides that an employer has to provide reasonable unpaid break time or permit an employee to use paid break time or meal time each day for the employee to express milk in the workplace. And this is for up to 3 years following the birth of a child. So this is important. Some states, we have clients who are in other states that actually require that an employer provide paid break time for breastfeeding, for pumping in the workplace. That's not necessarily the case with this law. The time can be unpaid. And also the employee can elect to use paid break time to pump. So we'll talk about a little bit more about that in a moment. This is the other big piece of the amendment. Basically, the new law provides that the employer has to make reasonable efforts to provide a room or other location in close proximity to the work area where an employee can express milk in privacy. And we'll talk a little bit more about what those requirements are and what this actually means. Of course, there's an anti-discrimination provision in the law. I think we're all pretty familiar with anytime there is a workplace law like that, it's included. Basically, the law just says that you can't discriminate in any way against an employee who is opting to express milk in the workplace. And this law is applicable to all public and private employers in New York State, regardless of the size or nature of the business. So those of us who do HR law or employment law, our HR professionals know that some statutes apply to employers that have 1 employee. Sometimes it's 4. With the federal, you're talking 15. In New York State, this applies to you even if you only have 1 employee. There are some notice requirements, which I alluded to a few moments ago. Basically, there is a requirement in the new law that an employer provide written notice of these changes to the law to employees who are returning to work following the birth of the child. So basically, there's a couple notice requirements in here. There's an annual requirement. So what we would recommend is you distribute the policy annually, and that could be to everyone, whether it's through your employee handbook update. There's also a requirement here that if you have an employee who goes out and takes paid family leave or unpaid leave, parental leave, takes leave for the purpose of having a child, that when they come back to the workplace, you provide them with a copy of the lactation accommodation policy. One thing that the law does say, although there isn't a ton of detail on it, is that if you have an employee who's wishing to avail herself or themselves of the benefit, they are required to give you advance notice. So basically, if an employee, that means if an employee is out on leave before returning to the workplace, they should give their employer notice that, hey, I'm breastfeeding, I need the accommodations, I need to express breast milk in the workplace. So there is a little bit of a requirement or an onus on the employee to let the employer know that they intend to use the protections that are afforded under the new amendment. So basically, let's talk about reasonable unpaid break time. So as I mentioned a couple minutes ago, this law basically says if you have employees who are breastfeeding and they need to express breast milk in the workplace, they need to be provided time to do it. So what the law and the guidance says is that reasonable unpaid break time is sufficient time to allow the employee to express breast milk, and that each break shall generally be no less than 20 minutes. If there is an issue, or maybe the room or the space that we're providing, which we'll talk about in a few minutes, isn't in close proximity to the employee's workspace, then they may have a little more time, so 30 minutes. Of course, these are the minimum times. Employees can elect to take a shorter break for the purpose of expressing breast milk. If you're an employer, you're probably wondering, okay, so at least 20 minutes, but how many times a day? Basically, the law says that the number of unpaid breaks an employee will need to take really varies from employee to employee. The infant's need, the nursing mother's need. But basically, a reasonable time frame is that an employee take a break to pump once every 3 hours. So that's kind of the guideline that we're looking at, or the guidepost, but it isn't necessarily, every 3 hours, that's it. It really, there is some flexibility built into the law. As I alluded to a few minutes ago, unpaid break time may run concurrently with regularly scheduled paid break or meal periods. So basically what the law is saying is that you have to provide an employee with unpaid break time. If the employee is provided with paid breaks at the employee's election, they can use that paid break time to pump. So, they can do it on lunch break, they can do it on another paid break. This is kind of an interesting piece of the law, which basically says, if an employee is taking unpaid break time to express milk in the workplace, the employer has to allow the employee to make up that time, basically before or after the employee's normal shift. so long as it falls within the employer's normal work hours. So this does not mean that you need to open early or close late because you have an employee who's expressing breast milk in the workplace and who wants to make up the time. This basically is saying if the employee at the employee's election, or if the employee asks, you can try to be flexible in that respect. But again, if your business is open 9 to 5 and your employee's shift is 9 to 5, you do not need to open early or stay open later. This is just a possible accommodation that could be granted if your business allows it. I should mention that all of these protections and benefits are available to employees during their basic work week, and if they work any additional overtime or additional hours work. So if you have an employee who comes in they work full time, maybe they're coming in for a few hours on a Saturday, these protections would also apply to the time that they worked on that Saturday. There's another requirement in the law that says that an employee may be required to postpone a scheduled unpaid break time for no more than 30 minutes if she cannot be spared from her duties until appropriate coverage arrives. So you have one employee on the floor, for example, one person on the phones. This provision of the law is basically saying that the longest time an employee can be compelled or delay their break time to pump is 30 minutes. So something to keep in mind in particular, if you don't have a ton of coverage, or you're in a situation where that employee, may be the only employee on the floor. So that's basically the break time requirements. I wanted to talk to everyone this morning about reasonable efforts and privacy, because as I mentioned a few moments ago, basically the hallmark of this new law is that it requires employers to make reasonable efforts to provide a private room or other location for the purpose of expression of breast milk. So let's talk a little bit about what that means. Of course, New York State has given us a little bit of an idea of what reasonable effort requires. Basically, they say that the room or other location must be provided for use of employees expressing breast milk, so long as it is neither significantly impracticable, inconvenient, or expensive to the employer to do so. So we'll talk a little bit more about what that means later. And being that it's New York State, we don't have a completely clear picture of what that means. But basically, the state has said relevant factors in determining, what is significant impracticality, inconvenience, or expense, or things that basically the DOL would look at to obviate the need for compliance with this particular portion of the law is the nature of your business, the size and physical layout of the business. Basically, if you have a small office space and maybe it's not practical for you to have a separate room dedicated just for the purpose of expressing breast milk in the workplace. That's kind of what they're getting at here. The type of facility where the business is housed, size and composition of the workforce, general hours of operation, and the relative cost of providing a room or other space for the dedicated purpose. So again, if you have a small office space and maybe you have an open office space, you don't really have extra, closed offices or extra rooms. You're a smaller business, maybe you are falling in the range of, 10 to 20 employees. That's something that the DOL would take into account, if there was ever any type of complaint as it relates to an employee not being provided the accommodations listed in the law. So we'll talk exactly about what the room or location provided has to entail, or what that room has to look like, the requirements for it. But the law is very clear that location cannot be a restroom or toilet stall. So if we're talking about setting up a space for an employee who needs to use the protections of this new amendment, it cannot be a restroom or toilet stall. The law makes clear that, if you have more than one employee who's breastfeeding in the workplace, or maybe just one, you can dedicate one room or other location for the employee to express breast milk and establish a schedule to accommodate the needs of multiple employees. So this isn't saying that you need, one particular location or room for every employee separately who may have the need to express breast milk in the workplace. It can be one designated space, and you can work with your employees, if there are multiple employees who need it, to schedule times to use it. There's a little bit of a carve out if you're unable to provide a dedicated lactation room or other locations. You can use a vacant office or other available room on a temporary basis. So basically, the law here is saying that you should have a permanent space if you can accommodate a permanent space for employees to express breast milk in the workplace. But if you can't, if you physically don't have the space, you have a small facility, things like that, you allow the use of a vacant office, a vacant room on a temporary basis when an employee needs it. But again, that temporary room, temporary space cannot be accessible to the public or other employees while the nursing employee is using the room for the purpose of expressing breast milk. So I think step one is if you can accommodate a permanent space, you start there. If you can't, you can use a temporary space when the need arises. A last resort that a law identifies, if you don't have a vacant office, you don't have a closed-in space, you can provide a cubicle for use by individuals expressing breast milk. But the cubicle has to be fully enclosed, so there can't be, one or two sides to it, or can't be any glass to it. And it's not otherwise accessible to the public while it is in use for expression purposes. And the law is very specific that if you're going to go the cubicle route, the walls have to be at least 7 feet tall to ensure the nursing employee's privacy. So, I think about our office, the cubicle walls are definitely not 7 feet tall. I would say maybe they're 5 or so feet. So just something to keep in mind if you don't have that dedicated space on a permanent or temporary basis, and you can opt to use a cubicle, but you probably need to make some modifications to it. So that's basically the rundown of what the space needs to be. But let's talk about what needs to be in the space per the amendments to the New York labor law. And I'll just note here that if you have employees in New York City as well, then this is really nothing new. This basically, New York State is kind of following suit after some protections that New York City enacted back, I think, in 2019. So, as is pretty common, as we know, working in human resources and employment, that what the city does, New York State typically will follow eventually. So basically, each room or other location that's dedicated for the purpose of expressing breast milk or lactating under this law has to be well lit through either natural or artificial light. So it can't just be like a dark room with no windows, is what they're saying. If the room has a window, there should be a curtain, blind, or other covering to ensure privacy. The room has to have, at a minimum, a chair and a small table, a desk, counter, or other flat surface. So those are the requirements. Employers are encouraged to provide an outlet, a clean water supply, and access to refrigeration for the purpose of storing the breast milk. So if you have a space, a closed-in office, and you're able to provide you have to provide a desk and a table, a flat surface. If you have an outlet in there, great. If the space is close to a kitchen, that's great. Or if there is a sink in the room, that's ideal. I don't think you necessarily need to, build a sink or run plumbing to a room that doesn't have existing plumbing. Obviously, a lot of employers have access to refrigeration for their employees. So if you have a lunchroom or a break room and there's a fridge in there, that's perfectly fine. You have to allow the employee who's expressing breast milk in the workplace to store their breast milk in that fridge, similarly to other people. If you have a mini fridge and you can provide one in the room, that's great. But again, if you are providing refrigeration for your other employees, you have to provide that same refrigeration to employees who are expressing breast milk in the workplace. The law does make it clear, though, that an employer is not responsible for ensuring the safekeeping of breast milk stored in the restored in its refrigerators or on the employer's premises. And of course, the employee is required to store express milk in closed containers and to bring such milk home with the employee every evening. So again, the refrigeration is a big emphasis here, but basically I think the takeaway is that if you're providing it to your employees, it has to be equally provided for the purpose of storing breast milk. Pretty common sense. It basically says the law says the employer has to maintain the cleanliness of the room. I think that, most of us would do that anyway. And an employer may not deny an employee the benefit due to difficulty in finding a location for purposes of same. So we talked about that a little bit more. The law basically says private room, temporary, permanent private room, temporary private room, cubicle. It defines what private means. I think it's a pretty common sense definition. It says that the room or location should not be open to other individuals frequenting the business. So not open to the public, not open to other employees, customers, etc. So basically you have to ensure that the space is private. A recommendation would be that you would have a sign available to put on the door, or to put, on the cubicle wall that it's in use, private, please do not enter, things like that. The law also says that the room or location should have a door with a functional lock. And if it's not available, as I just mentioned, a lock is not available, the employer should provide a sign advising the room or location is in use and not accessible to other employees or the public. So I think, the gold standard is having an enclosed space with a lock on the door. If that's not practical, then you can go the route of providing a sign that your employees can use when they're utilizing the room. The law talks a little bit about what close proximity means in terms of providing the location for the expression of breast milk. Basically, it just says it has to be in close proximity to the work area, which means walking distance, and the distance to the location should not appreciably lengthen the break time. So if you're an employer, you're probably wondering, what does that mean? It's a good question. New York State sometimes isn't the best at providing employers the most level of detail, but I'm thinking our recommendation is try to make that space within a 5-minute walking distance. We talked about this a little bit earlier. If you have more than one employee who has to take advantage of these lactation accommodations, you can have one centralized location for the use for all those employees who need it. But we have to make sure that it's at a reasonable distance. And as we discussed, I would also recommend that you work out some sort of schedule with the employees. If you're in that situation, feel free to give me a call or shoot me an email, and we can talk a little bit more about the details of that. The law says if you're an employer and you're located in a shared work area, so maybe you have half of a floor in an office space, or you're in a mall, you're sharing store space, things like that, you can cooperate with the people you're sharing the space with to establish and maintain a dedicated lactation room. But again, the room has to be at a reasonable distance from the employees using the room. So, I know for our firm, we're in a few cities. There are some situations where on certain floors we're sharing space. That's what comes to mind for me. If you're in that situation, you can work with the other businesses that may or may not share the space with you and try to, come up with a shared space. Again, basically, this is talking more about close proximity. If you're utilizing a common dedication lactation room, like we just talked about, you do retain individual responsibility for ensuring that it meets all the requirements of these guidelines. So basically, if you're going to go the shared space route, this portion of the law is saying that doesn't, exempt you from complying. You can't really push it off on the others that are using the space. Every employer needs to be cognizant of the requirements and make sure that they're being followed for that particular shared space. As we talked about, there's a non-discrimination provision in the law, pretty straightforward. You can't discriminate in any way against an employee who chooses to express breast milk in the workplace. And that is top down. So like any anti-discrimination or non-discrimination policy, of course, this means you cannot treat employees any differently because they are choosing to utilize the lactation accommodation provisions in the amendment. There are some suggested employer activities in the labor law that basically this kind of goes above and beyond the room requirements that we talked about a few minutes ago. The state has said that an employer may consider implementing one or more of these. Again, these are optional. If you can provide them, great. If you can't, I would say don't sweat it. Providing educational information in the room or area regarding the benefits of breastfeeding, allowing flexible work hours, job sharing, part-time scheduling to accommodate employees with children of nursing age. So again, this is not a required provision. And I think this is really specific to every employer and to the employee who's expressing breast milk in the workplace, and what effect, if any, that expression of breast milk has on the employee's duties. Providing an easily accessible sink to wash. You know, if you have a sink in your break room or your lunchroom, that really should suffice. Allowing mothers of nursing children attending on-site daycare to take breaks to breastfeed in lieu of pumping. Obviously very specific if you're in a facility or you're an employer that provides those services to your employees. You know, providing a list of lactation consultants, including protection for pregnant and breastfeeding mothers in the company's sexual harassment policy. We're going to talk a little bit about that later. Designation of a breastfeeding coordinator. Again, I think a lot of these are overkill, to be quite honest, but these are just some additional suggested things that can be provided in the space that the DOL has said, you know, we like to see these things. As I mentioned, I provided some other materials, the New York State DOL Nursing Mothers Bill of Rights. There is guidance from the New York State DOL regarding the accommodations. And there is that lactation accommodation policy. So I did want to go through that really quickly. As I mentioned at the beginning of the presentation, again, this is a new policy that employers are required to have pursuant to this amendment to the labor law. The policy that I provided with the materials is actually verbatim the policy that I pulled off of the New York State Department of Labor website. And I do encourage employers to just use that verbatim. You can put it in your handbook. You can distribute it separately if you have certain policies that you do once a year and things like that. So those are the materials. I encourage you to take a look at them. Again, I think most of the changes to the law really center around the unpaid break time issues and what you must or have to include in the room for the purposes of accommodating. One thing I wanted to mention as well, because there's a little bit of an overlap, is the Pregnant Workers Fairness Act. So I'm sure many of us on the call have heard of this. This is actually a new federal law that was enacted at the end of last year, and it went into effect in June as well. And basically, this is a federal anti-discrimination law that applies to employers with 15 or more employees, and it's actually enforced by the EEOC. And basically what the Pregnant Workers Fairness Act says is that if there are certain accommodations that an employee requests as a result of their pregnancy, that, absent an undue hardship, that the employer should grant those accommodations. So this is basically an ADA analysis, but as it relates to accommodations that an employer is requesting related to pregnancy, because as we all recall or may know, pregnancy itself is not a disability under the ADA. Complications resulting from pregnancy, medical conditions resulting from pregnancy are. But basically what this law is getting at, and some of the accommodations that the EEOC has listed are things like longer break periods, allowing an employee to sit or take, sitting breaks, allowing more bathroom breaks, allowing an employee to drink water, things like that. And if you have, I wanted to bring this up as well because the EEOC recently issued some regulations or proposed regulations on the Pregnant Workers Fairness Act, which, it's proposed right now. They're supposed to go into effect before the end of the year, but there is a comment period. And in the proposed regulations, basically, there are some suggestions for providing expanded protections similar to New York's for employees who are breastfeeding in the workplace in other states. So as I mentioned at the beginning of the call, if you have employees in New York, you have to follow the labor law, and it's pretty expansive. The Federal Pump Act really comes into play if you are operating in several states, and the states you're in other than New York don't have a state-specific lactation accommodation policy. The Pump Act would apply. But the Pregnant Workers Fairness Act regulations have kind of proposed similar protections to New York, so expanded protections. So if you have employees in other states, it can be a little bit confusing. I just wanted to bring that up because I think, if you have that situation, definitely feel free to give me a call or shoot me an email because it can be a little different from a compliance standpoint. But those are basically the requirements of the new labor law section that we talked about today. I'm just looking to see if there are any questions. This is a little bit of a shorter presentation than we would normally give, but I think last time we did the presentation, we talked about every new update for 2023. So I think we went over the time since there are so many new things to keep track of. I don't see any questions in the chat. So if there are none, Beth, that was the presentation for today. I think we kind of went through it quicker than usual, but it's a little more specific than our last presentation. So
Yeah, definitely more condensed into one subject matter instead of all the other updates.
yes.
Does anybody have any questions they want to ask? They can unmute themselves if they didn't put any in the chat.
Yep, or feel free to shoot me an email, shoot me a LinkedIn message. I'm available for any follow-up questions you may have.
Right, great. We will share the link to the recording with everyone later on. You can visit chemungchamber.org to register for upcoming seminars or find recordings of previous webinars. We have a couple of upcoming. August 31st, there is going to be an in-person seminar on communicating clearly, that is with long-run communications. And then on September 19th, another in-person seminar, proven options to retain and recruit your workforce with the New York State Department of Labor. For anyone interested in chamber membership, please contact the chamber at info@chemungchamber.org or call 607-734-5137. Many thanks to Ariana with Barclay Damon and to everyone for joining us today. Have a great day.
Thanks, Beth. Thanks, everyone.
Thank you.